I have concerns about you as well, sir, but I'm here about the child and the best interest of the child and making sure the child is safe. Okay, we are on the record. This is case D. Counsel, your appearance on behalf of your client.
Yes, Your Honor. James Jimmerson, Barnum 12599, on behalf of plaintiff, who's also present on my right.
Perfect, thank you. And defendant, your name for the record.
Pro se litigant for time being.
Thank you. So I do want to know you are self-represented for today's purposes because of course in our last hearing, you were represented by counsel. They since filed a motion to withdraw and you consented to that as well.
Yes.
Okay.
There's issues we need to work out with that.
Okay, so for today, you are self-represented, sir. I'm noting that at the last hearing, we discussed primarily the school selection issue, where we said ultimately, we may need to have an evidentiary hearing to go through the Marcella factors regarding that, both amazing schools, but that both of you would be allowed to start the process and put the child on the list so that you could both have the opportunity to apply for your school, okay, before the deadline for registration. So we left that there. Now there's a new issue. First, I want to address the request for media to be present here today. We do have media, which is our Nevada judges. Mr. Falcone is here. We do have a recent Nevada Supreme Court case that has found the closing of paternity cases and custody matters in the way it was done with this super seal unconstitutional, and that each judge now has the discretion to make rulings on whether a matter should be closed. So I believe we were both working super early this morning. I reviewed the request and granted it this morning at about 5:55, I believe is when it entered, noting that the parties, both of you would have the opportunity to orally state any objections that you have. Then about 10 minutes later, counsel, I saw your objection was filed. Sir, then we tried to reach out to you as well. And I believe you filed a couple things today, but not on point regarding a response or objection to the request to have this hearing open and that the media be present here today. So I'll let you respond orally if you have a position, but counsel, you can go first if you would like to add anything to the objection file.
I don't have anything else to add, Your Honor. I appreciate the court working so hard so early, and we stand on our papers.
Okay, so let me just understand your position for the record. You're not necessarily opposed at all to the camera being here, the hearing being open to media, but you do have a request to potentially close a number of documents and have those documents sealed.
Your Honor, our objection to the media request was specifically dealing with the 24-hour notice issue, so it was a procedural argument. I had spoken to Mr. Falcone over the weekend in terms of kind of what he intends to pursue. Obviously, we would want to make sure that things such as the image of the child are protected. I've already received those sorts of assurances. In terms of unsealing the file, we would request 60 days to present to you the reasoning for why certain documents should either be sealed or redacted, effectively putting into action the Falcone decision. And so we would have the ability to do that in a timely manner, while also recognizing that the court ultimately will have many more open proceedings, and this one being one of the first. So.
Perfect, thank you. Sir, your position?
I haven't had much time to look into it as a pro se litigant trying to get something ready for this. It's been one of the toughest things. I just got a Westlaw subscription today, so it should be easier. But in the meantime, I looked into the case a bit, and my position is simple. I was represented by Marshall Willick and the Willick Group, who opposed Mr. Falcone's organization. I think that he represents the height of corruption in the system because of the way that I and other of his clients have been basically robbed, and decisions that were made that have affected me, my daughter, and even the other counterparties in this room due to the corruption from this man. So
Now, when you say this man, who are you referring to?
Marshall Willick.
Okay,
And
not Mr. Falcone.
No.
Okay.
And so when I looked up the case, and saw that Marshall Willig was a part of trying to seal or trying to prevent the access to cameras. And then I saw the ACLU was supporting Mr. Falcone's organization. I contribute to the ACLU. It's every time I spend and give them any money, it's the best money I've ever spent. The way I see it, if Willig is against it and the ACLU is for it, I'm for it.
Okay, so we have no opposition. And I will note Mr. Jimmerson's procedural objection about the late filing. Thank you for that. We did have a holiday yesterday, but I did review it. We have Mr. Falcone here. So regarding the request to submit a basis to have some documents sealed, sir, do you have any response to that? Let me just say my concern. There are some sensitive topics here, and the concern is always about protecting the child and the child's best interest. I can say that I have viewed some of Mr. Falcone's videos that are often on Facebook, and the videos are typically done in a way where the child's initials are used, but not the actual name, or the child is not viewed at all. In this hearing, I don't think, we have a very young child in this case, I don't think the child would ever be in court testifying or anything like that, so it's probably not an issue here. But any party can renew their request or lodge an objection as we proceed. For instance, when we have the evidentiary hearing, if we get that far regarding the school selection, if for some reason you believe that there will then be an objection because of the sensitive nature of some issues that may be presented, of course, I'll allow you to renew or make any requests at that time.
I may respond.
Okay?
I am open to conferring with the plaintiff on this matter, and I think we're going to agree for the most part. When it comes to protecting our daughter, we may be at odds, we always agree, usually. So I think we can keep on.
Okay. Now, are you saying regarding closed hearings or protecting documents by having them sealed, or the big issue that we're here for, the school selection? You think that you can reach an agreement there as well?
I'm talking about this sealing of documents and protecting
Okay.
or protecting.
Okay. Well, since this is new to everyone, let me make a clear record, and I like that the Falcone decision that we have now, we're actually discussing at our next judges meeting to make sure that we're all consistent with how we address these and make findings, and that our orders are similar. So I want to state, for the record, the factors that I must review. Although there's not an objection here, there is in the future. It's the party seeking to close the hearing must advance an overriding interest that is likely to be prejudiced by having an opposition or a closed hearing. The closure, must be no broader than necessary to protect the overriding interest. Trial court must consider reasonable alternatives to the closing and must make adequate findings to support the closure. So if we have to deal with that specifically in this matter down the line, we will do so. Okay, so moving on to our status check for today's hearing, starting with you, Mr. Jimmerson.
Yes, Your Honor. We are here because in the last 2-3 weeks, there have been some serious problems and erratic behavior demonstrated by Mr. It begins on January 30 of this year, the day before we took his deposition. Mr. Saldi, can you please play Exhibit 13? This is a clip from his deposition on January 31, where he shows a recording from the day earlier, January 30, which is he's recording himself speaking to Miss in front of as he picks her up at 3 p.m. that day.
And while we're waiting, counsel, you referenced the deposition and concerning behavior with the last hearing, and this is follow-up regarding that.
Yes, Your Honor.
Sir, once we hear this, you'll have an opportunity to respond ultimately.
Yep, that was Exhibit 13.
You need to share your screen.
That way, as a government, you get what you wanted to do, and I get to pick her up.
Ted, please share the video screen.
Okay.
Thank you.
Instead of picking you up at school and then bringing you here for situations like this, me picking her up. Yeah. It's an idea. Right? I mean, hey, that way you get it. That way as a comrade, you get what you wanted to do, and I get to pick her up.
Thank you, Ted. Can you please bring up Exhibit 5, Ted, the video from the deposition at 11 a.m.? There was a significant number of exhibits that were discussed during this deposition, and upon review of the video, I did not see this happen live, but upon the review of the video, we see Mr. take a pill during the deposition. Mr. Soldi?
We are back on the record, and the time is 11 a.m.
Before we get into the actual specific documents that you produced, Mr. I do want to go through and compare Exhibit 8 with, I believe, Exhibit 7, which was the responses to the request for production of documents. So we looked at
Sometime later in the afternoon, approximately 1:59, take that clip. Can you please bring up Exhibit 4, Mr. Soldi? We see the ongoing concern that I have, how Mr. is testifying, behaving. You'll see it yourself, Your Honor, him slurring his words and being obviously impaired at this time.
Did you stop calling me bitch? I have not. I can't remember, but yeah, there are records. There are records of what?
Can you give me any reason that would explain why, if at all, you stopped calling this a bitch?
Because I was disgusted when I finally looked over all of the messages and decided this has to stop. She's the mother of my child.
When did you decide to look over all the messages and say to yourself, she's the mother of my child, this needs to stop?
Reviewing your OC motion.
I'm sorry,
Reviewing your OC motion.
so it was after we filed our OSC motion, we reviewed it, and that's when you said to yourself, no more.
I was pretty disgusted by the entire picture.
You still haven't stopped calling her names though, right?
I think there's a once in the past 5 months.
What's that? I didn't hear you.
I think there's a once in the past 5 months.
Do some math here. 1 month would be beginning, end of January, so the beginning of January, beginning of December, beginning of November, beginning of October, beginning of September. So that'd be 5 months. Beginning of September would be 5 months. Is that
I said 4.
4 months?
Yeah. 5 or 4, around that time. I'm not sure exactly, but that time frame. I don't know the exact, around, give or take a few weeks.
Mr. I'm getting terribly concerned with the slurring of your words.
Slurring of my words.
Yes.
Okay, so what do you want me to do?
I
You
need
can
you
pause
to
that,
affirm
Mr. Soldi, I appreciate it.
that you're competent to testify.
By contrast, Your Honor, and Mr. Soldi, if you could tee up Exhibit 6, this is an example of how he testified in the morning when the deposition started, before he took that pill at 11 a.m.
Concern, repeat that.
I have.
You have, that's, you have given a deposition.
Yes, I have given a deposition.
How many?
This one.
And when was that?
I think it was around, it was December 15th, 2016.
do you remember that date exactly?
because it was exactly the date that I had injured my spine, December 15th, in 2010. And I remember it was ironic to the attorneys that we were deposing, we were going over deposition exactly 6 years later. That's fine.
And that was a civil matter?
Yes,
I presume you were the plaintiff?
I was.
So, I'm sure you remember the rules of the deposition, but I want to go over them again. Do you
You can pause,
understand?
Mr. Saldi, I appreciate it.
Oath obligates you to answer my questions truthfully and completely.
From there, we see a number of examples of continued erratic behavior. On February 1, after we have our hearing, Mr. appears in my office, unannounced, unwelcome, uninvited, sits at our in our reception area for some time, then sits in our parking lot for some time, purportedly waiting for the police. We then have the following week, on February 7, where we have a 10:50 a.m. appointment for at her ear, nose, and throat doctor because she is needing to undergo surgery. And so this was an appointment in advance of that surgery. Mr. Saldi, can you please share your screen to show Exhibit 10? This would be in the appendix of exhibits to the motion. It would be page 112 of the PDF. At 10:50 a.m. on Wednesday, you will see Mr. wearing a robe at that time. More importantly, Mr. was the one that made the appointment for February 7 because he had missed the earlier December pre-operation appointment from 2023. Mr. Saldi, you need the appendix of exhibits, so that PDF, and it would be page 112 of that PDF.
Appendix to the OST or?
To the motion proper.
Can you see it now?
Page 112, please. This is a screenshot of the Talking Parents video call at 10:50 a.m. on that Wednesday morning. Later that day, Mr. would take a med-match drug test, and we would receive the results 1 week later on February 14th. Mr. Saldi, can you please bring up the supplemental appendix, or excuse me, the supplemental to the application on order shortening time? I think you had it right there. Can you scroll up? No, that's the appendix of exhibits to the supplement. Can you give us the supplement itself on that one page? It's another PDF, Mr. Saldi.
Will the appendix to the OST?
It's the supplemental application to the order shortening time. Or it's a supplement to the application. Excellent, thank you very much. You see here, Your Honor, the December 27 drug test results and the February 7 drug test results. And what you see is something quite staggering. You have Mr. tests positive for Adderall and Klonopin, and you see the same positive test results, but in quantities that are substantially higher. Specifically, the Adderall positive test in December was a 322 ng per milliliter versus 5,898 ng per milliliter for the same test on February 7. A similar substantial increase in his Klonopin concentrations were found as well, going from 415 ng per on December 27 to 1,472 ng per ml on February 7. So an 1,800% increase for the Adderall and a 3.5 times increase for the Klonopin. We supplied this to the court on February 14, a few hours after we received these results. We then see, Your Honor, just this last Saturday, and Mr. Saldi, please bring up supplemental exhibit 2, it's the video. This is a video of a call between Mr. and at 6:06 p.m. You will see that he is eating dinner. You will see that Mr. is what appears to be in his bed. We don't know what clothes he's wearing. You will see the expression on his face.
Exhibit 2?
Exhibit 2, that video. It's the supplemental exhibit 2. It's that video. You need to share the screen, please. Thank you very much. I appreciate it.
Are you still napping?
Thank you very much, Mr. Saldi. It is an 8-minute call, and throughout the 8 minutes, and we supplied this to the court as part of the supplement. Mr. appearance does not change. If you want to scroll to the very end, Mr. Saldi, we can see just a screenshot of the end of that video.
In the cup without the straw now that it touched your
Thank you very much, Mr. Saldi. I appreciate it. This evidence by itself would warrant the requested relief that we had set forth in our original motion. And it is actually quite robust, Your Honor, not because the goal is to harm Mr. or to embarrass Mr. but in fact for Mr. to get the help that he needs. The court looks, we asked for 8 different specific requests, 6 of which dealt with communications with his doctors, making sure that he reported to them, that his doctors would provide reports to us, that we would have a robust dialogue between them, that they were in contact with one another, that the side effects of his medication were going to be reported so they would accurately be able to assess whether or not he needs to have a change to his prescription, a change to his medication. Changing something that is so obvious that we see here, that he is suffering from real problems. And rather than take drastic steps, Your Honor, to materially reduce his visitation, we asked for a requirement that he have supervised visitation and that he refrain from driving, be ordered to refrain from driving while exercising that visitation until we have a report from his medical professionals certifying that he is safe. That he is safe to drive with his daughter, that he is safe to exercise unsupervised visits. Prior to the filing of the motion, we followed EDCR 5.501 to the letter. I had extensive email communications with prior counsel. I had extensive phone calls with prior counsel. The result was a Friday afternoon, Friday evening agreement to what we asked for. The court sees it in Exhibit 22, a copy of that email. Mr. Saldi, can you show us Exhibit 22? This is going to be in the appendix of exhibits to the original motion. It would be PDF page 274.
Can you see it now?
Yes, please switch to page 274, Mr. Saldi.
74.
274. This is the first page of the copy of this email, and the court will see that the request for relief in our motion is nigh identical. I believe that there may have been some phrasing of words that were just a touch different, and maybe 3 words that are different from what is requested in this February 8, 2024 email and what is ultimately requested of this court. That evening, prior to the filing of the motion, we didn't file until the following week. My client, after there was a representation by counsel that he had spent significant time in their office that day, that he agreed to these things in principle, obviously language for SIP and order would be in the future. My client asked Mr. himself, do you agree to these things? Right. And we see it in the talking parents. She attached a copy of that email, and his response immediately was grateful to receive this, checking now. And then included in the next message, short answer, yes, as I said in emails before, ask James for what you want and you'll get it. We then see later that evening, I even outlined how I plan to get parameters for full compliance organized to get these agreements in action ASAP. And this agreement that had been memorialized in writing and talking parents was performed on that Sunday. So Mr. enjoys visitation on Sunday, Tuesday, and Thursdays. He has 5 hours on Sunday, 3 hours on Tuesdays and Thursdays. On Sunday, supervised visitation from a approved supervisor, and the minor child had been dropped off by Ms. and had been picked up by Ms. There was no driving. But then we see this in the application for a shortening time that was filed the day after we filed our motion, starting to renege on that agreement. We start him saying, the only reason I'm going to have Natalie over is because he loves her so much. And then on Thursday, an outright refusal to perform the agreement. I'm not going to have a supervisor. I insist on picking her up. He actually drove to Ms. home to pick her up that afternoon, despite the agreement that had been in place just days earlier, and that had been performed. Your Honor has seen it before. Sometimes people say they have an agreement, but there's a discussion error. There's a communication problem. They're fighting over the agreement 5 minutes after they entered the agreement. Here, we see the parties perform the agreement. We see what they're doing, right? Mr. agrees, and then he performs it. Unfortunately, he is not following through on that performance. He is not following through on the promise. He is not holding up his end of the bargain, which is what necessitated the filing of the motion in the first place. Because if we had an agreement, we would submit a stipulation order, and we'd be home free. Fortunately, we couldn't do that, okay? Because the silence from Mr. his counsel, I'm not going to speculate as to what was happening, but we see what happened the following week. It wasn't the following week, it was the following day. The submission of the order consenting to the withdrawal of counsel. Your Honor, this, in my view, is a very conservative approach to what is an obvious problem. My client is not substituting her wisdom for the doctor's. She wants Mr. to get the help that he needs. It is clear that he needs the help, and that we want to give him every chance to do right by his daughter. Unfortunately, what we see here, he is incapable of doing so without that help. And again, in the interim period, until we have certification from his doctors that he is safe to drive, and he is safe to exercise unsupervised visitation, we request that those orders be entered, as well as the orders requiring him to do those things, to make sure that his doctors are in communication with one another, that he's got regular reports going to them. Because as we demonstrated, he has 5 visits with his mental health care professional from December to December last year. We don't have any evidence to suggest that he has a more recent visit with his doctors. And given what we see here, 5 visits across 13 months is inadequate. We need to make sure that his therapists are talking to a psychiatrist. We need to make sure the psychiatrist is talking to the ketamine, the doctor who performs the ketamine infusions. They need to be on the same page, because while independently they may think he's doing all right, if they don't have the collateral source, they don't have the collateral information to make sure that what they're doing is in Mr. best interest and that they're giving him the best treatment, we see what happens. We see someone who takes a pill during a deposition and is now slurring his words uncontrollably just hours later. When you would think it's one of the most important legal proceedings that he is engaging in, given the limited amount of court activity that we've had prior to the last couple months. So with that, Your Honor, respectfully request the court effectuate the stipulation between the parties and enter the orders as requested.
Okay. Sir, I know that was a lot. You will have time to respond. I just want to guide you a little because, of course, it's always about the best interest of the child, and it's concerning not just the allegations, but that it appears that there was an agreement between you and mom, and that you acted on that agreement. So I'm not sure if with the consent to withdraw, to have your counsel withdraw, if that had anything to do with what appears to be a change of heart. But what I really want to understand is if there's an opposition to the request, which I must agree are conservative, considering some of the behavior we discussed at the last hearing, the pictures of pills, all the allegations about drug use, how can I ensure that this child is safe in your care without the parameters that they've requested, that it appears that at least at some point very recently, you had agreements? Go ahead, sir.
Well, first of all, it's because there's something, an issue with myself and the Smith Law Group where we had agreed they would turn over the emails, correspondence, and now they're not willing to yet. We're going to work that out. But as much as I do know, Jesse Allison, we spoke for, let me see, I'm just gonna read this, clearly I had this prepared, about this so-called agreement.
So hold on, sir, are these communications between you and former counsel?
At the time when the agreement was being made, supposedly, because Mr. Jimmerson says there's an agreement made, and I'm going to outline for you exactly what happened around that time. And it's very disappointing to me too, because I wanted that agreement to work, and I really worked hard despite documented. If I can get into Microsoft Teams, I can show you, and the exhibits, constant harassment of the plaintiff, and constant antagonism, and I kept trying to simply make things work based on the threat of under the threat of motion practice. If I didn't sign something without consulting my attorney, saying my attorney already said I agreed, but let me get into the details for you. Let's get to the facts. That Mr. Jimmerson sent a letter to Jesse Allison Esquire, my attorney of record at the time, a letter of settlement of this case with other stipulations concerning his claim that my alleged drug abuse, despite contrary evidence for months. And I agreed. I agreed to the stipulations because it was also connected to a statement of settling this and giving me information to help them settle. This is a settlement negotiation, and I was like, I agreed to everything, fine. Let's just, and so she said, he agreed. So I was like, let's just work this out correctly, because it's an agreement between attorneys, and there are stipulations, she says, are just far-reaching that violate HIPAA laws, among other things, and they need to be done correctly. So she, at the end of Friday, we spoke for an hour. I spoke to my attorney at 2 p.m. on Friday for almost an hour and agreed to all terms and conditions, looking to settle this case as soon as possible. The letter, which I could read to you in full, has other things attached in the stipulations. But
Probably
anyway.
not a good idea if it's all about settlement negotiations because we have a trial
Yeah.
pending.
So a conveyance to my attorney about an agreement, not a signed stipulation in order for execution, which Jimmerson claimed he would produce, and he did produce, apparently, that evening. Miss Allison was not able, because it was the end of the week. She has a family, she reviewed it on Monday, and I do have a copy of an email where she said, hey, I'm drafting a counteroffer, but I'm going to contact them. Let's get this settled. I was talking to her about the progress we were making, and but it was not a signed stipulation in order for execution. And once Attorney Allison was able to review the stipulation, she told me for her last conversation with me, before the weekend was out, on Monday, February 12th, she reached out to James to speak about the proposal. And immediately, a motion was filed. And he said, after he filed the motion, he said, I can speak to you now. So that seems like not only the breaking of a deal, but bad faith negotiation to try to extract information within the means of an agreement. And there is also evidence of me speaking in a conference, Mr. Jimmerson, where he was trying to get these med-match results, which I can clearly explain why they aren't what he claims they are. And he did so in a conference claiming that they are related to what Ms. wants for settlement. It was a settlement negotiation. And I have the transcript and the appendices. It is, let me check one sec. The transcript is number 5. And it's, you can have a look over that. But basically, he claimed, I'm going to read just an excerpt of it, actually. I can find it. Let's see. Basically, Mr. Jimmerson, I believe, said, he essentially said to me, well, we need this for settlement negotiations, as also stipulated in the letter, which has been submitted to the board. Also stated by Ms. as what she needs for a settlement negotiation. A settlement negotiation was in process. And so, but funny thing is, he said that the court has, you're ordered by the court to give this information, and that's not true. I even confirmed with him, I was like, wait, so we're doing this for the sake of the settlement negotiation, because the reason I'm taking other extra med match tests after the first one came back fine was the result of a conference between Ms. Allison, Mr. Jimmerson, for over 40 minutes in chambers before we met with Judge Duckworth the last time, and they agreed, Ms. Allison wrote a letter about this, that those med match test results were conditional, or were agreed upon as a basis for expanding my custody and finally getting overnights. And that never happened, and I still went and did the med match test anyway. So these are two different negotiations for different types of settlements, and they are being conflated, and Mr. Jimmerson straight up misrepresented what they were for, and then later seemed to gloat about it, send me an email, the original email from November 3rd, that had mentioned nothing about a med match test, almost, and then use that test as some sort of testimony against me, which I do believe is a violation of a specific stipulation in the Nevada Code concerning information shared during a deal-making process cannot be used against you. I have it in the actual legal argument here, but rather than get into it, allow me to explain. So, it was very disappointing for me, because not only had I started trying to agree to this process, even though I said, hey, listen, I need to have my attorneys at least go through this. She said, sign it now. I said, joking, I said, if I do anything extrajudiciously to sign anything, or sign any documents without checking with my counsel, Kurt Smith is going to throw me off his building and then throw himself off after me for the stress I'm causing the poor man while trying to represent me. I have to go through the proper process to step about what can I do to help you in good faith gestures show that I'm cooperating. We started looking at people to supervise for a couple days, and for the interim until this deal was worked out. And we agreed on someone. She started coming over. She even wanted to send her father over, who I don't think he likes me very much, but I said, hey, as long as he understands that I respect him as his grandfather and the delight to have him around, that's fine. As soon as we had one or two visits, you can see in the messages submitted during that time of the entire set of conferences that take place between February 9th to February 14th. And Ms. consistently is trying to change the goalpost. And then she consistently just withdraws and says, we'll just leave it to our attorneys. Because it seems like it's working out, and I'm going above and beyond, and I don't think that was her agenda. And furthermore, these are, and a lot of the conversations extracted were during this supposed deal-making process. But they never intended to make a deal. This motion was drafted throughout the weekend with pieces well drafted. With pieces of information taken throughout the weekend as we were trying to work in good faith to be used against me. And it's just sad. I even stated in the opposition that I'm okay with the stipulation being carried out still, but they have to pay for the costs. Because just like, they haven't even paid for the drug test ordered by Duckworth, and they were ordered to pay for them, and they stated, and you can see this in messages, she refuses to pay for them until she gets what she wants. So I'm still okay with it. They simply need to pay for the costs, and there is just the issue with the harm and the mental issues of this causing. That's a bigger problem. That's a much bigger issue. Now, what is being claimed is mental impairment, essentially. And I believe, and modifications in custody for that. I believe that there are statutes in place for evidentiary hearings on those grounds, absolutely. And not only that, but my motion itself, and again, Jay needs to give me a moment here to just like properly cite it, is my counter motion is for court-ordered custody evaluation pursuant to Nevada R Civil Code P 1622, meaning I've been claiming for a while that Ms. is doing things that psychologically harm our child. I believe I have evidence of this that I'm planning for the OSC. I'm trying to get it together right now, and Ms. is claiming that I'm in danger. But what we do know is that there's a child involved, and someone objective needs to comment out there. Take a look at both of us, take a look at what's going on, and figure out, is someone in danger? Is someone impaired? What is going on with the child? What does she need? Is the father fit to provide what she needs? I agree with that. I've accepted admonishment from the court. I've submitted 2 drug tests. I've even admitted to Judge Duckworth, I didn't have to, that I did psychedelics on the record. I keep trying. And every time I try, something new is just thrown at me. And as Ms. Allison said at the beginning of last year, every time she doesn't get her way, she causes problems. And I don't know what she didn't get this time, but I think it's because she wants a ski trip coming up. And I said, no, I'm not leaving town for the entire year. I couldn't even go to Tokyo for 30 hours. And the OSC is about her, or that I filed is about her leaving without permission. So maybe our lawyer attorneys can work that out. But I think that was suddenly.
Because I was trying to follow,
Sorry.
and I think I know where you stand on everything else, but then the ski trip, so you believe that all of this is about a ski
Suddenly I
trip?
said no. And then suddenly things started to change in terms of her participation with the agreement. And I also believe she always planned to file a motion and tried to make that joke that was brought into the court last week, where people went into my bag. There's no chain of custody. I don't know I haven't touched those pills. I don't know what's in them. But I know it wasn't that full of white pills. Okay. I can bring it back, but you don't know what the chain of custody is for me. Yeah, so what I'll just simply say is this. We had negotiations for an agreement. Mr. Jimmerson pulled out and filed a motion instead. And it was based on, in the letter, for avoiding motion practice and for resolving this deal, resolving this issue between us. Even if I pay her legal fees or whatever. And we were going to begin that process so that we could move on. I was very hopeful about that. I've been attending we attended 3 schools together. When he talks about me missing appointments, I went to that appointment a bit late, but I was there for over an hour. I got several printouts. There's text of me going through NIH research concerning all this information, and then there's also in the exhibits a transcript of a appointment she had in LA that I was able to make it to. Furthermore, someone who brings, an officer of the court, who brings things that they stole and tries to admit it as evidence, calling other behavior strange, like waking up from a nap on a Saturday. I woke up from a nap on a Saturday, and I'm on drugs. I recently closed, it's in the appendices, my first high-ticket client on a new job while dealing with all this drafting. It was yesterday. Information about that in my contract. I built my house for my daughter. Built it for her.
Okay.
And
Well, let me just say this, sir. Thank you and congratulations on the client yesterday. We've covered many topics, and I don't want to get away from the most important topic, which is the subject minor, and whether the subject minor is safety or care. The most basic allegation is that the medications you're taking are causing impairment that may present harm to the child when you're in your care. What's interesting is that you're saying even today you have a full agreement as long as they pay. I haven't talked about that yet. What I'm inclined to do is say, let's go with the agreement, because today you're saying that you agree, and then we can always split the payment now. It was represented at the last hearing that don't have an issue with finances per se, but we could do retaxing of payments at a later date. We have an evidentiary hearing for the school selection right now. We can talk about all outstanding matters at an evidentiary hearing. That's fine. The critical issue right now regarding the temporary orders, because you're correct, an evidentiary hearing is required to change custody, but for temporary orders, when there's allegations about the safety of the child, and then here we have another level where you're saying that you have an agreement, you have a stipulation, just as you've had in the past regarding the drug test, all of that happened before this case was transferred to my department. I want to believe that you made those agreements, as you're saying, someone that would create a home and build a home just for your child, so that the other parent would be more at ease regarding the concerns, but that your agreement was for the child. So I appreciate that from you, sir, and at least with that, I find that both of you are putting the child first. But sir, I can't ignore it in a deposition. I don't believe counsel mentioned it today, but of course, going through the motions, they go through their script in the deposition asking if you're under the influence of any medications, if you've taken anything that could impact your testimony, or if there's any impairment going on. And it appears from the video, I'm mentioning it because you didn't address it, but that you ingested some sort of pill with a fork in your mouth and sipped something, and then the allegation, the representation from the persons there watching you at the deposition is that there was a noticeable change of behavior. That's just one example of the things that's been mentioned today. I'm just mentioning that one for the sake of time, but seeing that causes concern about what's happening behind the scenes. The reason why is because people are usually on their best behavior, at least better behavior, when they're being recorded, when they're doing depositions that they know will be likely introduced in an evidentiary hearing, and you can be observed taking a pill. What typically happens is a witness at a deposition will say, I have a prescription, or I'm going to need to take a break to take my prescription medication, letting everyone know on the record that this is something that is okay and normal, this is prescribed medication. But on the video, it's like you're seen trying to sneak and take a pill. Then there's a conversation later that wasn't mentioned between your counsel and Mr. Smith, your counsel at the time of the deposition, about that and whether the proceedings should be suspended, and the back and forth. So I think there's great reasons why you agreed, and then your issue is really not with Ms., not regarding the best interest of your child, because I feel like you're there for right now. The issue sounds like it's with Mr. Jimmerson, and whether you believe he was negotiating in good faith or all the while planning this motion and sliding it in there and using information against you while you thought this was information to settle in good faith. And I understand that. We will deal with that as well if you're going to proceed on some sort of claims there. Typically, I'm not involved in settlement negotiations at all, shouldn't be privy to that because I'm the trier of fact for the evidentiary hearing. So I don't know how far you want to go with that. I don't know if you plan to hire a new counsel, if there's any allegations regarding what happened with your former counsel. But for right now, and for the sake of time, because I know we have a lot of parties waiting here today, we had a lot of issues to address, even issues regarding media and outside of the substantive matters here. So I also have concerns. We'll go over exactly what your response is, if any, regarding the meaning, because you mentioned, sir, in your response about what those values mean from the drug test and how you volunteered to do those drug tests, but that you have explanations. That's fine. If you can file your brief in writing regarding all of those issues, I want to understand your position. And okay, and everything is so rushed right now, but I want to make sure that you have the opportunity to fully address those. And then I'll reserve on those issues. But right now, for the child safety, I am finding good cause to essentially adopt the agreement that you already had and ask that you all split any costs associated with that now.
So I can't afford that.
Then, at a later hearing, once we can get into sworn testimony and more evidence, we'll have the opportunity to decide who should ultimately be responsible for the cost. Depending on who prevails, we'll entertain everything regarding attorney's fees and costs. I want you both to understand that the fees and the costs are not the important matter right now. It's making sure that this child is safe, that you're not driving impaired. I would like a better understanding from your doctors of what your prescriptions are, what your diagnoses are, the safety, everything related to the safety of your child in your care. I have concerns about you as well, sir, but I'm here about the child and the best interest of the child and making sure the child is safe. I don't know that it's not true that you weren't just groggy waking up from a nap. I don't know that to be true. What I'm looking at though is the totality of the circumstances and these little building blocks, what I've seen in all the pleadings and from last hearing combined with this hearing, and some of the actions from your end, sir, that I'm not going to make a judgment about at this time, just that I need more information so I can understand what's going on. We don't need to address the pills. I addressed that last time. I agree. Law enforcement was not involved. There's many issues here. We're moving forward, but we're moving forward needing to understand how first of all, what the diagnoses are, what medications you're prescribed. Considering the medications you're prescribed, how to reconcile that with the drug test results and the amounts listed there and this what appears to be a super high increase in the levels that we've seen for both the Adderall and the Klonopin. Thank you, counsel. But we'll talk about that later. Right now, and it's very detailed, so I won't read it into the record, but for what I have with the agreements that you had regarding the request, it's fair for right now. Sir, if you go back and look over, because they're very detailed requests on what they're asking, and you have an objection to certain provisions, I don't know if you're saying that anything's a violation. What I heard you say today is that there's a full agreement except for payment, so I'm adopting that very temporarily. What I want to do, we have to slow this down, and I don't want to wait because Madam Clerk, when did we set our evidentiary hearing? Yes, that's not till June. We can't wait that long. I want to come back for a status check in about 30 days to see where we are, primarily for the safety of the child. So what I gather is that we have an agreed upon supervisor for the child who is Natalie. Is that correct?
It would either be Natalie or they would use one of the paid supervisors, supervising firms that they've used in the past as well.
Okay, and you're okay with that, sir?
Shiloh, I believe it was Shiloh Super. Shiloh Monitoring was the prior.
The issue
Company.
is that, I can't afford the cost right now. That's the issue.
How much is it for the supervision?
I mean, it's at least like 30, 35 an hour, and Shiloh's even higher. And,
Okay.
but I just like, if it's consistently when I see her, I want her to see Natalie.
Well, let me ask, so Mr. Jimmerson, he's saying that he cannot afford the supervision cost at this time, and that Shiloh's even more expensive. Is there a response? Again, we come back to the expense.
Yes, Your Honor. He testified during his deposition, because we went through his bank statements. How does he budget? Because he receives infusions of money from, as he said, either family or Sasco. Sasco is a business that he is a 50% member in, totaling 6 figures last year, and where he spent $187,000 last year, according to his bank records. And I asked him, how do you budget on a monthly basis? I mean, I know how much I make every 2 weeks. I'm able to plan what my budget is, and he goes, I'm not like you, I don't have to have a budget. If you give me the 10 minutes to look through the deposition transcript, I would show it to you, but it was wild answer.
I recall the exact same testimony from the hearing last time, or argument regarding his testimony, sir. Any response, because this is of course what they argued at the last hearing, that you're basically bragging that you don't have a budget, unlimited resources.
It's just, my income is very clear, it's been consistent. They're welcome to misrepresent it. I don't have counsel right now, because I can't afford that, which would be useful. And
But sir,
I don't
do
see
you
any
have
symptoms.
access to,
my parents have been trying to help me. I borrowed money to try to pay off my attorneys to help me get to trial. And things have just gotten out of control. And I have to get a grip on this and still be around if she needs me. But I wanted, I mean, if they're requesting drug tests and they're requesting these stipulations, I feel like, which are far-reaching, I have to say, then an agreement I feel like that we had, that I'd spoken to Jesse about was, hey, but they need to pay for it in the meantime while we settle the rest of the case, and those two are
I
also
understand, and I'm okay with splitting it equally right now above both of your objections until we figure this out and have some sworn testimony and more evidence. But let me ask you this question. You mentioned a custody evaluation. Are you requesting a custody evaluation as well? Because depending on who you hire, PhD level, those are generally tens of thousands of dollars.
I mean, now that we're just moving forward and making really on this, I'm not sure that's necessary at the time. I would just say that I would I should have just originally perhaps come in unprepared to address this, because first of all, I think you can hear me in that deposition and hear what I'm saying, speaking hoarsely, and I can go into that, but we don't have time for making a ruling now. I'm willing to suspend visitation until evidentiary hearing on this matter, specifically because I don't want the court to be concerned, but I can't afford it right now, and if I can't afford it, then I can't I'm paying my mortgage on time. I'm just getting my job together.
Okay, so wait, now because, sir, now you're changing
Sorry.
your request and your argument. Evidentiary hearing is not until June. Are you asking to suspend visitation with your child through June versus splitting the cost of a supervisor? I'm hearing is about $35 an hour, and you have limited hours on a few days a week. Is that your request?
Not for the evidentiary in June, because that's an OSC. If we could have, I believe, custody changes concerning mental health that they are requesting and mental impairment. First, they have to be testified to by an expert.
Okay, well, wait, sir. I'm asking about your request to suspend visitation. Generally, if we have an evidentiary hearing, we'll hear all issues. We'll start on that June date. We can always add time. If issues are properly added, we can address that. But I was leaning towards adopting your agreements, doing a status check in 30 days to see where we are, see if you've submitted additional information regarding the request from your medical providers. But is it now your request to suspend visitation through June because you cannot afford to split the cost for supervision?
I wouldn't say through June, there's a time we can reconvene so I can be more prepared for these arguments, to show that I am not a threat to my daughter. I can wait till then, but I have to pay my mortgage. And I just.
That's more important than spending time.
No,
Your Honor, my client's happy to pay for half the costs. She does not want to do it. She loves her father. We don't want there to be an extended period without visitation.
I don't want that either, sir.
I just, like, this is.
Let's do it this way because I don't want you making a request that even mom feels are not in the best interest of the child. I can see the way your child lights up on that video when you're there, even if let's just say you're groggy. Let me just make the order that we have supervised visitation so that you can still see your child. I'll adopt your other agreements. We'll come back in 30 days. That gives you more time to kind of digest everything that's going on. I am a true believer of parents. This is your child. This is your fundamental right. And you have plaintiff even saying, I don't want our child to not be without you for an extended period of time, which I think is beautiful. So don't please make any rash requests. I understand that the process, the procedure is daunting and you just lost counsel. So this gives you time to decide if you can afford to hire counsel, if you can seek help through any other program like legal aid if you qualify, give you more time to look at everything and see what you can do while you continue to have visitation with your child. So Madam Clerk, I'll make those temporary orders, but we'll essentially pass all of this, and also for the sake of time, let's go out about 30 days with Madam Clerk. Clearly, I need to find a session where we have extra time. What date did you pick?
It's April 1st, 9 a.m.
Okay, we'll delete our 9:30. Is that good for everyone? That's a Monday morning, 9 a.m. on April 1st. And we would set aside a special session for you all, so it's just your case being heard at that time, if it's possible for all of you to make it. I'll also grant, of course, appearances virtually if you need that for your convenience via Zoom.
That schedule works for us, Judge. I do want to alert the court to one thing.
Okay.
We included in our papers. My client has a standing work event. She has a client meeting every day at 3:15, not every day, every Thursday at 3:15. And so before all this happened, Mr. would pick the child up. She would have the work meeting and then go pick up. We would ask that there either be an alternative visitation made so that those 3 hours would be preserved, either extending it on Sunday or a different day, or that there would be someone else like her father to take her back and forth for Thursday. Some alternative so that Ms. doesn't lose the time, but so that she doesn't have to lose her her standing work meeting.
Of course, and you all have been able to agree. The request is so that you do not miss your time on that day because mom has a work visit. That's fine. You're free to agree on an alternative so that the child can be transported and that you have that time. If not on that day, if it's not possible logistically to get the child to you, then you shall be granted extended time on one of your other days where mom is there.
And that's the most appropriate, Your Honor, for Sunday, because his current visitation schedule on Sunday is 8 a.m. to 1 p.m. So it would attach then a 1 p.m. to 4 p.m. extension if there is no other alternative available for that Thursday or Friday.
That's perfect, to make sure that at least has the same amount of time there. Sir, are you available on that Monday, April 1st at 9 a.m. for about an hour hearing?
I believe so. I have to. My grandmother's dying, and I have to go see my mother, because my mother not be able to go. So my oldest, I'll see. Tentatively, I'm not positive, but that's just. But
I'm sorry, let me just address the date first, sir, and I'm sorry to hear that that's happening in your family. Let's set that date so that we have you all on calendar. And of course, if there is a stipulation to continue, always talk to council first. If you're not gonna be able to make it again, I granted you the availability to appear on Zoom. So if you're not in the jurisdiction, you can appear virtually. We can do it that way as well for your convenience, sir. But we'll get that set so that we have it, so that we can check back in about 30 days. And council, you'll submit an order.
Yes, I will, Judge.
One
Oh,
question.
go ahead.
If I'm unable to fulfill some of these visits, will I be able to work out makeup time with the?
There needs to be the appropriate notice provided. I mean, it can't just be, I'm out. So,
Of course.
I mean, this is not,
So how about you go through those dates that you know you can't make, give them a list, and give them a proposal for your makeup time. That's how we typically do it, and then you all can go back and forth if scheduling is an issue. It sounds like today, and I appreciate this and commend you all that you tend to make agreements in the best interest of your child, and then it's the background issues. So if there's any issues, typically I'll have the parties submit their competing requests, just an email, and I'll go down the line and I'll try to make it as fair as possible. But I'm sure if we're just talking about hours here and there, that you all can work that out. Okay?
yeah, the parties historically have been very good about, trading, X hours for Y hours, that sort of thing.
Exactly. I hate to see you here now, but I'm optimistic that we'll work it out.
It may address at least the mismatch testing. If we
Let's, I have to, for the sake of time, close out. Right now, we're beyond 12 at this time, sir, but you're free to, of course, to make any supplemental briefing, as long as that's served on council, and then we'll address that at the next hearing. No orders, no temporary orders that I adopted today. These are just the ones that you agreed to. I'm not even considering that at this time. Okay?
not considering
As far as the drug testing and the levels increase and all of that. Because that's kind of assumed by your agreement that you're going to get more information for your medical providers anyway. And like I said, if there are certain specific provisions that you feel you cannot comply with or be a violation of HIPAA or something, then you can send that list over. Steve, shaking your head, no. So it shouldn't be an issue, but if an issue arises, just let council know. See if you can reach an agreement.
Thank you very
Okay.
much.
We're off the
We're
record.
gonna go off the record and end this.
I appreciate all the time, Your Honor.
Of course. Thank you all.